And welcome back to Attorneys on Call. At any time, call the 800 number on your screen. We have operators standing by live, and also go to whitleylawfirm.com. The website there, that's a great first place to go if you think you might need representation. Now, a lot of people get injured on the job. Sometimes it's serious, sometimes it's not. However, that sometimes people are a little bit hesitant about filing that workers' compensation claim. Ben Whitley is back in studio with us. And Ben, I know that those first 30 days of when someone files a claim is extremely important, right?
It is. And what I've found, and the reason I wanted to talk about it, I've also found in talking to people, it's also the most stressful time of the claim, the first 30 days. When an accident happens at work, immediately people think to themselves, am I going to lose my job?
Yeah.
How am I going to pay for the next meal? You know, paycheck to paycheck, hardworking North Carolinians are out there, and if they get hurt, they're worried about that, you know, and a lot of times when I'm able to talk to them very soon after the accident, that's the first thing they'll ask me is, you know, can I get fired if I file this claim? And what I want to tell everyone out there is that there are very strong laws that protect people, that you cannot be terminated if you file a workers' compensation claim. You cannot be retaliated against. That's the word they use in the law, is a retaliatory firing.
Okay.
But you can't be retaliated, or you can't be demoted. So you can't be demoted or you can't be fired as a result of filing the claim. So it has to be connected, of course, to you filing the claim. If you were to file the claim and you get terminated and they say, well, we just can't take any injuries around here. Well, that's against the law. So you can't do that. Can't happen. Another concern, I feel like in the first 30 days, people worry, well, I don't want to hire a lawyer because I don't, you know, I've got a good relationship with my employer and I don't want to sue anybody and I don't want trouble. I don't want things to be dragged out and lawyers getting involved. And that's a myth because, first of all, you know, when you hire a lawyer for a workers' compensation claim, you're not suing your employer. Often the lawyer is just dealing with the workers' comp insurance company, which is going to be the company that's in charge of paying for your medical treatment and paying for your out-of-work checks. And it's important during those first 30 days to let your boss or your supervisor know you got hurt. You know, a lot of people, if they don't think it's that serious, they may get a back injury and feel like, wow, okay, this little pull, a little strain, things are probably going to be okay, so I'm just going to, you know, see how it is the next day. But don't do that because there are deadlines. In that first 30 days, the first 30 days you have to have filed a written notice to your employer about the accident. So stress happens, but remember, those deadlines are there and they're important.
So a written notice could be email? Would that work?
Sure. I've handled cases in which that was in question, and an email written to your employer will certainly count. Text message. Something in writing, anything in writing.
Anything in writing.
Absolutely.
Okay.
And you just got to let your employer know, even though you may not believe it's that serious, that you have been hurt, it's important to know. So you've got that deadline out there. You know you can't be fired for having a workers' compensation claim. You certainly can't be fired for hiring a lawyer. And hiring a lawyer does not mean that you're filing a lawsuit. Another thing to think about in that first 30 days of an accident is getting medical care. You know, it's important that you follow your employer's guidelines as far as how they require you to receive medical care. Oftentimes this can be found in your employee handbook if it's a large corporation, but they're going to have certain criteria that they're going to tell you that they need to go to a certain doctor because they're in charge. You know, in a workers' compensation setting, they get to tell you where to go to a doctor. In my experience in working with cases in North Carolina, it's usually an urgent care type facility that they're going to initially send you to if it's not too serious. If it's, of course, very serious, you know, the emergency room. But if it's something where you're able to get yourself to a facility, it'll often be an urgent care facility. In that first 30 days, you're often going to be required to do a drug test. And that is something that is the insurance company and the employer can require from you. So that's something to keep in mind. But telling the doctor in that initial visit everything that hurts is very important. I see this a lot in knee cases, Drew, where people may bump their knee, hurt their shoulder, and they thinking about their shoulder, they hurt their knee a little bit, but they're not thinking too much about it, and they may mention it to the doctor, Doc, I've got it in my shoulder, and the doctor treats the shoulder. A couple of weeks go by and that knee starts flaring back up again. Well, when they go back and ask for treatment for that, they say, well, you didn't report it in your initial visit to the doctor. We don't think it's related. And that knee can develop into something more serious. So that first 30 days, very important. Tell your doctor everything that hurts, even if you don't think it's that serious.
Okay. Now, what about when we get to that end of the case, the last 30 days? So that was great information about what you need to know those first 30 days. Keep those deadlines. It's got to be a written notification to the employer. How about when you get into that last stage, that last 30 days?
The last stage of the case is going to be really depending on what happens with what your doctor tells you. Your doctor is going to give you what's called MMI, which is the end of your treatment, maximum medical improvement. And what that means is the doctor's decided that you're not going to get any better or you're not going to get any worse. You have plateaued, so to speak, of your treatment. And at that point, the doctor's going to assign a disability rating or a percentage disability and may assign permanent work restrictions. If he assigns permanent work restrictions and you can't go back to your job, your case goes down probably a settlement road. If he does not assign permanent work restrictions, gives you a disability rating, your case probably goes down what we call a 26A, which is technical. It means your case stays open. Okay, you don't settle your case. You may go back to work for your employer. So that last 30 days of your case, last month or so, there's going to be a big question about whether or not you should settle your case or whether or not you're able to return to work. And a lot of that has to do with what the doctor believes your permanent work restrictions are going to be.
Is there ever a case where you can go to your own doctor, or are you mandated to go to the employer's doctor because it is a workers' comp case?
So if it's an accepted workers' comp case, that means if the insurance company is providing medical care and paying for your out-of-work wages, then they are in control of your medical care. They can tell you which doctors to see. Now, if you've got an attorney, there are certain things attorneys can do to request for second opinions, either based on the treatment, having another set of eyes look at the treatment plan, or on that disability rating we mentioned before. You do have the worker who got hurt has a right to a second opinion on just that disability rating. But sometimes things happen in the case, and I've recently handled some, where we've had to ask the insurance company to agree to a second opinion. They disagreed, and then we had to file for a hearing in court, and we ultimately won that, where the judge forced them to give that injured worker a second opinion.
This has been great. We're just about out of time, but thank you so much, Whitney Butcher, Ben Whitley, Whitley Law Firm. At any time, call that 800 number on your screen. Go to whitleylawfirm.com. You can also request one of these free DVDs. Great information. You can watch those videos right there on the Whitley Law Firm website. Thanks so much for joining us for this edition of Attorneys on Call. We'll see you next time.